remotely a chance to join and see how our attendance is shaping up.
And there you go. Nice. People will be like, what's the deal with Bulgaria? We want to know what the deal with Bulgaria is right here. It's really interesting.
Let's see. Okay, I'm going to try sending it live on Facebook as well.
Anybody else notice the notch in Italy? Would you like to know more?
Let me get this logged in here. But it's all on the audio.
Yeah, I'm close front, so but I can't see food on myself, so that's good. Can't see that.
Okay. We are live on Zoom, and we are going live on Facebook, and this is being recorded. And hopefully my phone's mobile hotspot has the bandwidth to accommodate all of it. If not, we'll have to drop one of them. But everything's looking good so far, knock on wood. All right, it looks like we have people signed on Zoom. All right, we've got a number of participants there. And we've got the chat function on Zoom enabled. We're going to distinguish the chat function from the question and answer function. It seems a little bit redundant to me, so let's exclusively use the chat function. And I will serve as a moderator for the questions both live and through the chat function on Zoom. And it is 11:56 by my clock, and we will go ahead and get started with today's meeting. I feel kind of surrounded here because I've got the camera for the Zoom in front of me and a live audience behind me. So I'll try my best to split the difference and hope you'll all bear with me. Thank you so much for your attendance. This is the Houston Northwest Bar Association. And traditionally, we've had all of our events here at the wonderful Campione restaurant on Cutton Road in Northwest Houston. And it's been a wonderful venue, but ever since the outbreak of COVID-19 and the social distancing measures implemented by governments on all levels, we've had to delay our meetings. We've tried a number of times to get something like this to happen, but thanks to April and Robert, our speakers and presenters today, this is the first time we've been able to make it happen. And thanks to the hosts here at Campione and their wonderful service, this is a hybrid approach, and we hope it'll work out well. My name is Paul Freeman. I am the current outgoing president of the Houston Northwest Bar Association. Here also in attendance is our vice president, Ruth Ann Toops. She will be succeeding into the presidency for the next board term. And we have two candidates to fill the vacancies in the vice president seat and in the secretary seat. Before I get to that, I'll extend a special thank you to Paul Rory, who served as our secretary from 2019 to 2020. He would have loved to have stayed on, but he's got other commitments, including the addition of a new baby to the family. So congratulations to the Rory family. Sorry, I'm not certain if the baby has been delivered yet or if it's expected soon, but again, congratulations to you and your family. It's proposed that for nomination of Vice President, Bo Bowen of the Bowen Law Firm, who's been a member for several years now, be nominated as the Vice President. That Corey Sells be nominated as the Secretary, and that Gidget Tyler will return as our Treasurer, who's been serving at least a few years now, and she's done an excellent job, and we're grateful to have her continued service. So if you are participating via Zoom, feel free to chat your votes for yay in the affirmative for all the positions, nay in the negative for any objections you might have. I suppose I could give a moment to each of our new candidates. Corey is here live and Bo is on the chat. So we'll give Corey a minute to introduce himself here. And then if Bo would like to make any statement, I'd be happy to read that on his behalf here in front of our live audience. So Corey, if you'd stand here in the middle so we can see you on camera.
And I gotta see those out of the camera. Is that perfect?
That's great.
Blocking people behind me. There we go. Corey Sells, I've been a practicing attorney since 2010. I practiced here in the Houston area for most of that, outside of 6 months in McAllen. I practice in commercial, real estate, civil litigation. I'm happy to come and volunteered. I'm not campaigning, I guess, against no one to become the secretary. Hopefully help with Ruth Ann and Bo's time as president and vice president.
Wonderful, thank you. Okay. You know, I can even see if I can give Bo the chance to, Bo, if I turn your video on, would you want to say something here for all of us? Let me give a chance there. Okay, Bo?
Yeah. Hello all.
All right, we've got you on audio, Bo, go ahead.
I want to thank you all, hopefully, for the opportunity to serve as a vice president. I look forward to working with these two gentlemen. And I'm, of course, open to any ideas on how to make us better. And again, thank you all for this opportunity. I look forward to meeting you all in person and create some great CLEs.
Thank you, Bo. All right. We'll go ahead and take a vote for Vice President Bo Bowen. All in favor?
Is there a motion that they need? Motion first of all.
We're being asked for a formal motion. Okay, so it is, I move for a vote on the election of our 2020-2021 board members with Bo Bowen as vice president, Corey Sells as secretary, and Gidget Tyler as treasurer. All in favor? Aye. Okay. We have an affirmative vote from all in the live audience, and we have no negative votes on the Zoom. Okay. Unless there's any other business to be brought before our group, I'd like to introduce our speakers and their topic, and then I'll be happy to turn the time over to them. Again, if you have any questions, either here in our live audience or on Zoom, I suppose our live audience members could raise their hand, and I'll call on them and give them a chance, and then anyone on Zoom. I'll try to interject where appropriate so as not to interrupt our presenters too much, and we'll see how it works out. April Prim is an attorney. She practices with her husband, Robert. Is that right?
Yes.
Okay. I want to make sure I got the names right. You know, maybe it'd be better if we heard a little bit from yourselves on what you do and maybe how you do it.
Okay, well, we're talking about evictions today. I have a slide about us. We graduated from Texas Tech School of Law and we're licensed in 2012. We started our firm in the Woodlands in 2014. Initially, we just did general civil litigation, but over time we realized that a big need in this area was what I like to call property law. Lots of times it's just landlord-tenant real estate law. Since we started our firm, we've been representing landlords, tenants, property managers in various capacities, doing things like evictions, security deposit disputes, and breach of contract cases. Do you have anything else you want to talk about us?
We pretty much, as far as the structure of our practice, we work together on every case. April tends to handle all the paperwork, and I handle the putting on a suit and going to court. So as far as every little part of it, we do all the cases together.
I promise I will slow down as soon as I am done talking about myself. But would you like us to get started, Paul?
Yes, please go ahead.
Okay. We're going to talk primarily about residential evictions because they are the ones where the rules are laid out very nicely and it's a little bit clear. And I think that this is what most people come in contact with when they're thinking about an eviction.
So evictions are special in that they are a lawsuit that is just about evictions. It involves any lawsuit that's brought by a landlord against a tenant just for possession. There's other things about adding into the eviction lawsuit, but it is a one objective kind of lawsuit. We say landlord tenant, but the statute really means anyone with a superior right to possession. Usually you're talking landlord tenant, but sometimes you're talking about somebody with a sublease, somebody that has a roommate, or more commonly a foreclosing bank. You know, the bank and the tenant don't really have a relationship, but it's the bank that's trying to get possession. They have a superior right. So that's the situation where you'll see a non-landlord that's in one of these cases.
But in most situations, you are dealing with the landlord and the tenant under the lease contract. We've got parties laid out pretty simply. You're looking at an owner of the property, usually, and a possessor of the property, and the dispute between them. We wanted to add in one of the groups that's not often considered is the occupants to the property that are not named on the lease. For people that are stepping into the world of evictions, you want to make sure that you consider the occupants and that you include them in your lawsuit when you eventually file.
And the trick to that is that they're not a named party on the caption. You don't have to serve them, but you should always put on all of your notices to vacate, all of your letters, all of your petitions, all of their occupants. And this comes around to the idea that the objective here is possession, and possession is the state going to the property and saying, you're not allowed to be here anymore. And the constable is going to have the court case, and it's going to say landlord versus tenant. And if it doesn't say all of their occupants, then they don't have the right to remove those people that are on the property. So it's very important to always put all of their occupants on all of your pleadings and letters.
One of the things we also want to mention is lots of times when people show up to court, especially if their first time in JP court, if they don't do it very often, you're going to come in contact with a lot of people that are not lawyers but are authorized to represent parties. Sometimes that's the property manager, sometimes it is a close friend, but be prepared for that and prepare clients for the eventuality that they may be going up against someone in court that isn't the named party on the lease and that they might feel has no place there, but that it is perfectly permitted and even to be expected in a lot of situations, especially with younger tenants.
Right. It's certainly the situation that when you go to court and you're opposing representative is not a lawyer, that your lawyer brain says, UPL, they can't be doing this. They're in the capacity as a lawyer. But in this, at least in evictions, it's allowed. It's okay. So don't worry about it.
And we have a lot of cases where a property management company will take on an eviction and then on appeal will end up being the lawyer taking over for the property management company. Oh, can you not hear me? I saw that there was a comment. Okay, let me get a little closer to my computer. I'm not sure how the audio going out works, but as far as impact and risk, one of the things that we did want to address is that it's really easy to say that you're going to evict somebody as a landlord. And it's really easy to, jump into that idea. But we also want to say that, evictions are something that should not be taken lightly, and that an eviction can haunt someone that has gone through the process for a very long time. Most rental applications moving forward in their lives will ask them, have you ever been evicted? So we want to make sure that people, take a breath there before jumping into it. And then also that a lot of times landlords think, oh, I want this over with, I'm going to do an eviction. And one of the risks that you take is that the property that you own is under, not necessarily always a greater chance, but sometimes a greater chance of undergoing extra damages because people are leaving in a hurry, because people no longer feel like they have a stake in taking care of the property, or even intentional damages from angry tenants that are being evicted.
I have a question on those lines.
Yes, please.
As a practical matter, how common is it to actually recover those additional damages?
Well, we kind of touched on that a little bit later. It's not very common. Most of the situations when you're dealing with an eviction, you're also dealing with a judgment-proof defendant.
And especially for the sake of the civil litigators, you're dealing with a judgment-proof defendant who is not living at their address and you have no idea where they are. And they're also tenants, so it's not like you can look them up easily on HCAD to find their new house. So as far as preserving as much of the property as possible, trying to get somebody to have a stake in the process helps get them out. And you'll always have a tenant, if you can get a mutual lease termination, they'll leave the place broom clean because they feel like they have some stake in it. And because you're never gonna, if they tear out the place, if they leave holes in the wall, that's just something you have to deal with. You're never gonna get that money back.
Yeah. Sometimes is a waste of time as a landlord to go through negotiations, but often things like cash for keys that we mentioned, where you are giving a tenant who may just be in a tough situation a bit of a stake in what's going on and giving them the opportunity to move to a different place and vacate the property. Can you still? So it says that they can't hear me. I'm kind of maybe is it over here?
We've got you back now.
What's that?
We've got you back now.
Okay. But the idea that if you are willing and able to give cash for keys, give money to the current tenant so that they will be able to move to a different property without filing the eviction, sometimes that works out better for everyone. Or at the very least, try to get an agreement to vacate on or by a date certain. And one of the certainties with that is that when you do walk into court, if you do have to go with an eviction, after that, you've got a piece of paper that is signed by the tenant that makes it very clear that the tenant is not supposed to be at the property any longer and that they've agreed to that.
And one of the parts of the counseling part of the job is that the landlord is used to getting money from the tenant and not giving money to the tenant. And so it's difficult to try to explain, I know that you do not want to give this person money. You have no legal obligation to give this person money, but you could give it to me and it could take months, or you could give it to them and it could take weeks. The only other, I deal with the psychology of this because I have to stand outside the courtroom talking to people, is that sometimes, and depends on the person. Offering cash for keys will sometimes make people think that the landlord's case is a weak one, and that's why you're trying to offer cash for keys. And it's not because we have a weak case, it's just because we know how long this takes. So even though the right answer is cash for keys, when it turns back on you, go, yes, this is how some people are. Don't be surprised by it.
One of the other things that I wanted to mention before jumping into just the steps of the procedure is taking precautions beforehand when you enter into the lease. Make sure that there are open communications and way for tenants that are experiencing financial difficulty and things like that to communicate to the landlord, preferably in writing, as to what's going on. Adhering to the lease terms from the very beginning. If a tenant is 3 months late on the rent, and you accept the money, and then they're 3 months late again, and you accept the money, and then you're 3 months late again, and your landlord's accepting the money. A lot of times, that kind of pattern is trickier to overcome. It's definitely not impossible, especially at the JP level, but it's one of those things where you do have to present more evidence and explain more if you're going with a non-payment of rent case.
Right. So the defenses are, they will throw every piece of spaghetti at the wall they can. And one of those pieces is that you have entered into and you waived your duty to your right to receive rent on time. And it's a bad argument. JPs don't like it, but it's still one that can gum up the works. And so as much as you can, try to stick to that rental payment schedule, just so that you're not wasting your time bringing out every rental payment over a year when you're trying to stand in front of a judge.
And then one of my other recommendations is financial screening. It's not always easy, but a lot of applications already ask for proof of employment. Actually look at the records. If there are people that are listed as employers that they say that you can call, give them a call. It's not foolproof, but it is helpful. We've had lots of situations with landlord clients, property management clients, where they get a lot of documentation and they haven't even necessarily looked at it. They've just kind of ticked the box that they got it, and it leads to a situation later that really could have been avoidable.
Whenever somebody calls and says, I need to evict somebody, I say, okay, is it for non-payment of rent? Is it holdover? Basically, the lease term is over, or a lease violation. And that's very, very important because of how difficult it is to win. The very easiest is holdover. All you have to do is prove maybe a notice and what today is. So that's a simple type of case. Non-payment of rent is the next easiest. And really it's just a couple pieces of paper showing account statements, when checks were sent, when checks are deposited. You will see sometimes people coming in with the check. That can be a fact issue you don't want to get into. But in a lot of JP courts, especially up here around the Woodlands and even in downtown Houston, the judge will say, if you are here for non-payment of rent, this is going to be very fast. And there is one question: are you behind on rent? And if the answer is yes, it moves really fast. So the third one, and this is the one I really don't like having to do, because it's like you're being asked to do a real trial within 5 minutes, and that's lease violations. That's what did the tenant do that you want to evict them that wasn't related to rent? And this is things like having too many parties, having too many dogs. They're not watering the lawn enough. There's a trailer park, the things like that. And judges don't like to evict people for things that don't necessarily have associated damages to them. It's just a lease violation. And so if you have a client, you can look at the lease and say, yes, you have a lease violation. Yes, the lease says you're allowed to evict under the default provisions. But just be careful, because that's the kind of situation where you're gonna have a big fight on your hands, and it's a fact issue that is normally for a real big case, but you're gonna have to do it in 5 minutes. So in those situations, just be careful.
Which court has jurisdiction when you're starting an eviction case? You are always going if the amount of past due rent when you're dealing with, with money requests exceeds the jurisdictional limit, then you're going to need to file a separate lawsuit for the rent.
And on where you file, the important thing is that it has to be in the precinct where you're filing.
You guys still see me?
Yeah, we've got you on video. It sounds like every time Robert stops speaking and then April starts speaking, it takes a while for the mic to start picking up April. I'm not sure exactly what that is.
I just got black on my screen, which is interesting, but you guys can still see me?
Yes.
Okay, let me try to figure this out. We'll switch sides in the meantime, but I don't know what happened. All right, one sec, you guys. I apologize.
That's all right.
It is really strange because it is completely dark over here. Can you still see my slides and everything?
Yes, it's on the slide that says notice to vacate, and that delivery can take place by hand.
Okay,
mail.
let me slide that back up because I don't. Yeah, all right, because I have no visual whatsoever. I've never had this happen with my computer.
And we're good 20 minutes in, or 20 minutes plus. So
let me check real quick. Maybe we can jump on. If Rob can jump on his Zoom, can you jump as a participant?
And I've got the slides here on mine, so I can pull them up and share it from mine.
Okay. Well, I think my thing though, if you want to.
Yeah, let me pull them up.
Share. I just need to be able to see what slide I'm on.
Yeah, and so if I share, oh, but your screen's black. I see.
My screen is completely black.
Okay.
I have no idea what this could even mean. Okay, let me see. I apologize, everyone. This is so strange. This computer never misbehaves. Yeah, well, we can't. I guess he could scroll for us. Okay.
Yeah.
All right. Yeah. If you do, can you unshare my screen so that you can share yours?
Yeah.
All right. Because we've got a separate computer that we can do the slides.
Okay. I'm sharing it from mine, and it looks like everyone can see. And we left off where basis for the eviction.
This is really funny.
Yeah.
I just need to be able to do this here.
No, they can't hear us. We can't tell.
Okay. I wonder what happened.
There we go. Okay. All right.
Got
April,
this.
you're able to see the screen share?
I can see nothing.
Okay.
Yeah, I'm gonna have to trust you on the scrolling if that's okay.
Not a problem. I'm happy to do it.
We're just gonna look at our PowerPoint
Yeah.
on the other computer to go, oh, what are we talking about?
So we will go to the slide and we will be going completely blind. So if people can't hear me, please let me know.
I don't know if they know.
Well, he can tell me. Okay, so
So we're on the initial evaluation of the case. What are the basis for eviction? You were talking about a lease violation.
Right. Next one, jurisdiction. And you can't just, the jurisdiction in most of our lives is just county-based and maybe subject matter as far as federal versus district versus county. But with evictions, because it has to start in JP court,
If you are evicting Walmart, you have to start in JP court, which is a funny case. But when you're picking your precinct, you have to pull up the precinct map, like go to the constable's precinct map and figure out, is this house on this side of the street or that side of the street? You get kind of a feel for it after a while, where your precincts are. In Montgomery County, we don't have places. In Harris, we do have places. So we know you have a choice when choosing your place. So if you get used to this, you will find the judges or the courts in the places that you prefer. Is it 4-1? Is it 4-2? Is it 1-1? Is it 1-2? And you get to pick. And so pick the one that's either closest to you or that you just happen to like.
But it does have to be in the correct precinct, or they will dismiss your case and they will keep the filing fees.
Yes, they will keep your filing fees. If you're asking for rent that exceeds the jurisdictional limit, you're just going to have to go get your rent somewhere else. So this is why acting quickly is important, because that number keeps going up every month. But on the bright side, if you do have more rent than the jurisdictional limit, all you're looking for is possession, which is the objective the whole way anyway. Next slide. Check local rules, local forms. Pretty much Harris County, like us and Montgomery County, they make forms for you. You just go to their website. As a lawyer, I go, I don't like these little check the box forms, but they're really handy because the judge is used to them. And when you go up to prove your case, they just look at the boxes that you've already checked that they're used to seeing. So,
and in all fairness, some of them are actually really good.
Yeah,
they're really helpful, especially for pro se.
So if there is one thing that can stop an eviction in its tracks, it's bad notice to vacate. Judges, it's the first thing they look at is, where's your notice to vacate? Notice to vacate, substantively, it needs to be an unconditional demand for the premises. Theoretically, you could say, if you don't pay rent by a certain day, I'm going to do this. I don't like it, but you'll see it. That's sometimes fine. But it needs to say, you must leave by X day. X day, according to the statute and your lease, is going to be, can say 1 day. Your TREC lease, your TAA lease, it's going to say 1 day notice to vacate. Even though it's black and white, feel free to ignore that and do a 3-day notice, because every JP I've been in front of looks for 3 days. They count the days. They don't care what your lease says. The other thing about it is there's a 10-day notice that has to do with attorney's fees.
If you're not asking for attorney's fees under your contract.
Yeah, under your contract originally. This is kind of if somebody's staying with you without a lease, but you still want attorney's fees. All right, next slide is just the statute. You can see why the notice to vacate can be the point that the best place for defense on this, because it's a very long statute.
And I'm not going to read that, but my intent with including it is just saying that when you're dealing with property law, there's a lot of contingent factors, and the code really does kind of try to address everything. And if there is a question that you don't know, looking into the code is very helpful.
So besides delivery, how did they get it? It can take place by hand. It can take place by mail. There is a Byzantine method by which you can post it on the outside of the door. In short, if you have and I always ask this to landlords, does the place have a mailbox? If it has a mailbox, mail it. You don't want to have to worry about having a witness there swear in court that they hand delivered it. You don't want to have a picture of the outside of a door and a picture of how there's no mailbox, or a picture of how there's a deadbolt, or all these things that qualify the statute. So in short, mail is great. When it comes to mail, I do both, just so that I can stand in front of the judge and say—
By both, he means certified and regular.
Certified and regular, correct. I can say I did both. People that are getting evicted aren't picking up their certified mail, but you want to have that little white card that they've stamped for you at the post office that said, here was the day that it was sent. And you want to have the USPS letter that says, here's when it was sent. And it will always say, try to deliver, undelivered, hold for pickup.
I think we have a slide somewhere little bit down, you don't have to find it, but it's basically, you're not dealing with the mailbox rule when you're dealing with the notice to vacate. It's calculated based off of the date that the notice to vacate was delivered, and the certified mail route gives you a little bit more security with that date.
Right. And so when you pick the day to hit the button on your lawsuit, give it some room, because the first question the judge is going to ask, notice to vacate, when was it sent, when was it delivered, and then they check the file stamp date on your petition to make sure that's after your 3 days. So on my slides, we are at will or month to month. Like I said, we posted the statutes for you to realize you got to read through this thing. But in short, just mail. When it comes to month, these are things like you stayed over on the lease and everybody's okay with it, or you're a tenant at will. Somebody's just living at your house rent-free or something without a lease. In which case,
Lots of times it's where a significant other has moved in.
right. In which case, that's 2 notices you need to do. One, the first notice is a 30-day notice of lease termination. That is, the lease will terminate on X day. Make that 30 days. This isn't a notice to vacate. A lot of people will think the 30 days is a 30-day notice to vacate. It is not. It is a 30-day notice of lease termination. After that 30 days, new notice, 3-day notice to vacate. So in your lease, of course, we'll talk about this. Specifically, your TREC lease is going to be a 30-day. Your TAA apartment lease is going to have a whole process on 60-day notices. So make sure you know which one you're dealing with. Okay, so we talked a little bit about why we're here, which is just get possession. The claim that you're going to be making is for possession. People will say, oh, but they broke this. They owe me late fees. Can I get this? Probably not. The statute doesn't allow you late fees. JP judges will not let you get late fees. As much as you have to go, yes, I know you're owed every dime, you're not going to get it here. You can get it later, maybe, but you're not going to get it here. So at the first phone call, possession is what you're looking for.
And I wanted to mention, but we're not going to go into it, housing covered by government assistance programs, whether you're representing a landlord or a tenant, that is something that needs to be considered from the outset, because doing something wrong in one of those cases can result in both the landlord and the tenant being kicked out of whatever program they are involved in.
And even the forms that you'll get through the JP courts in Harris County and Montgomery County have lines for how much is being received through these programs. The petition is, like I said, if you're using the form provided by the county, you don't have to worry too much about this except filling in all the right blanks.
They follow a code language that makes sure that all of the information that needs to be in there is in there. This goes back to the same idea with the precinct that we were talking about before. Just make sure that you're filing in the right precinct. Whenever you're dealing with a real estate question in landlord-tenant law, you're always looking for the court that is directly associated with where the property is located.
Next slide is attorney fees. Because we're dealing with a contract and we're dealing with a statute, attorney fees are awarded or awardable. And so they might be collectible. Your client will say, oh, but all the money I'm paying you, can I get that back? You can ask for it. It can be on the paper. Like we said, if you have any lease that was drafted by anybody, it's going to have an attorney's fees provision. Your petition will have a section, your even petition form will have a section of what paragraph of the lease is your attorney's fees claim. Write that in.
Paul, are you still there?
Yes.
Okay, just making sure.
I have no way to
It
confirm
had
it.
been a while and I hadn't heard any noises. So I just wanted to
No,
make
it's
sure.
great.
It would be really funny if we finished the hour and it was just us talking to ourselves for 30
No,
minutes.
there continues to be a little audio issues when transitioning between you and Robert speaking, but it eventually resolves itself and we can hear you again. So
Okay.
you're doing great.
So if you don't have a lease, or if your lease was on the back of a napkin, you can get your attorney's fees, 10-day notice, count your days like usual. Now, I've had situations where the landlord will file pro se by themselves, and then the tenant will go find an attorney, and the attorney will file all kinds of stuff. And the landlord will come to me and say, hey, can you jump in? And I go, great. Can you get attorney's fees? Well, did you put attorney's fees on your form? No, because I wasn't an attorney. I didn't think I was. And so I go, oh, okay, so here's your problem, is that I'm going to seek attorney's fees. But the only way to do that is to amend the petition to say, I would like attorney's fees. I suppose I could go in front of the court and just ask for them. They'll probably call you on it. And so you won't get them. But if you want attorney's fees, I have to amend. If I have to amend, that means that I have to reserve that petition. It's not like in regular run-of-the-mill court where you can just reserve by hitting the button on Texas e-file. You have to reserve with the constable because it's a whole new petition, and everybody, and the timelines are so short on this. It's long for a landlord. Oh, it's taken me weeks. For an attorney, we're like, weeks? This is nothing. And so because the timeline between getting served and the hearing is so short, asking for attorney's fees and having to amend your petition is just going to drag things out even more than it already feels like they have been. Further on attorney's fees, statute lays out how to do it. This is kind of in the line of nobody gets attorney's fees unless the statute says you're allowed to. Here's the statute.
Okay, these are some of the other documents. When you're dealing with an eviction petition, you're not just dealing with filing the petition. You also sometimes need some of the other ones right off from the very start filed. One of those is the Service Members Civil Relief Act affidavit and the certificate. Some courts require this only if you are at the trial stage and are trying to get a default. Other courts require you to file one right at the filing of your case and actually bring a fresh one the day of. It depends on the court, but it is always a good idea to be prepared. It is very easy to get these things certified as long as you have a birth date or a social security number. I recommend getting a photo ID if you're going to have a tenant, just to verify full name and birth date to keep in your records. But it's
right. When you go to the SCRA website, it is birthday, name, and driver's license numbers. So having those handy is very helpful. As for what you need to bring, you can file it with it. You can bring it the day of. I have even had it where I filed it. This was, I think, 1-2 on Shepherd.
Social security number 20.
Social security?
Yeah.
Oh. Where they had me pull out my phone and look it up while I'm sitting there in court, and I fill out an affidavit right in front of them. So it just depends. Be ready for it. Next is certificate of lapse on address. This is just like you have on any regular pleading or a default, really. It's just a piece of paper that says, I think they still live at the place I'm trying to evict them from. Nothing in the code I have ever seen that requires it, but a lot of judges require it, and so you do it, almost as a matter of course. New fun stuff, because of the CARES Act, there's a hold on all evictions for a while, so we're having fun trying to catch up on those. But specifically, if you are a covered entity and you cannot evict people if you have a mortgage that is backed under one of these federal programs. And luckily, at least as Harris County, as soon as you file, they'll hand you an affidavit. And the affidavit is broken down in all these different parts that says, I'm not a covered entity, and I know, and here's how I know that. And I'm either going to swear to it, almost like an unsworn declaration, here's some personal information, or here's a notary, and then here's the statute. So before they're going to let you go to eviction court over summer at least, you're going to have to fill out this CARES Act affidavit. And when it comes to how to know whether you are a covered entity or not, you're effectively just stuck with tell your client to call their mortgage servicer and say, hey, am I a covered entity? And they'll say no or yes. And then your client just fills it out by saying, I called and asked. There's no, unlike the SCRA, there's no piece of paper you can print out to say you are or you aren't. But you do have to do this affidavit. You do have to say why you know. Just say it's because you called. Next is service.
Okay, unlike with most cases that we deal with in civil litigation, service for an eviction case is court directed. This means that the constable is going to be handling it after you file your petition on their own timeline, and the timeline is very, very short. You're talking about the dates that I have on there where it's, court not less than 10 days or more than 21 days after the petition is filed. This also includes substitute service. You're not going to be filing a motion for substitute service if the constable isn't able to get service initially. They're just going to take care of that, and they're going to post as needed to get that service accomplished.
Right. It's very handy that you have to have the service with the constable on an eviction. It's just the rule, and so you have to do it. But as far as it goes, they prioritize these things, and also having substitute service handled for you is quite nice. One thing to note is that in some courts, if you get a default and you had to serve by substitute service, you might not get your attorney's fees or your late rent. You'll just get possession. I got mad at that one time until I realized that it's a due process thing. We don't actually know if this person who lives there was served with this notice. We just know that somebody on a lease at an address got a note on the door from the constable.
One of the other things worth noting, if you're representing a tenant, it's possible that a tenant might not realize that they have been served by substitute service if they haven't been handed the documents, and they might come in saying, I wasn't served. But then working through with them to explain substitute service is beneficial to really understand what's going on.
So it cut out just a little bit there, Robert. You were saying that it's substitute service, that's the due process issue, and not getting attorney fees or other costs?
Right. I mean, just imagine that if you, I gameplay this stuff in my head. If you wanted to get a judgment against somebody, and you didn't care who you just wanted a judgment. Well, you could file an eviction against a piece of land that you own, their name on the petition, and the constable would handle substitute service, and you'd go to court and you could get a judgment against just about anybody because the substitute service doesn't have anything. The constable handles it all themselves. And so a lot of times if you try, it's so fast, and the substitute service is handled by the court, I mean, just by the constable doing it, that not having notice before getting a judgment against somebody is a due process issue. And so just be aware that if you had to get substitute service and you're looking for a money judgment, you might not get it on a default, obviously. If they show up, no service issue. But I at least had it in the Woodlands and in on the I get it mixed up, 4-1 on Cypress Wood. I've had it where getting a substitute service and a no-show at court has made it where I only won possession. They didn't. If somebody's living there, they should see the thing on the door. You can get possession, but you might not get your money judgment, which, all else being equal, is fine. That's not why we're here in the first place.
Did you want to talk about then I have this slide for pretrial evidence gathering. Basically, it's just trying to get landlords or tenants to collect everything that may come up. Most of the stuff is not even a thing that a judge is going to let you have. It's good to have all of your documentation in one place before initiating any of this, because sometimes in JP court, a question is going to be asked or an accusation is going to be made. And if you have an answer for it versus not having an answer, it's going to go more smoothly. Those things, the lease, the notice to vacate, are very important. Payment ledgers from the landlord side, receipts from the tenant side, or logs where they've paid electronically. Police reports, especially if you're going to be trying to do an eviction because of a lease violation, maintenance logs. A lot of times as a defense, you'll see those things pop up. Text messages between the landlord and tenant, emails, letters, things that are in writing, HOA notices and other notices that have been given from the landlord to the tenant, and then photographs again, especially for those lease violation accusations.
In that sense, there's no discovery. So you have to have everything ready to go. You don't know what they're going to bring. And second, in a lot of Harris County courts now, everything needs to be e-filed because of COVID. And you'll get a checklist. Before you'd bring your lease and you'd hand the lease to the bench, you'd hand the notice to the bench, and everything would go that way. Now, everything needs to be e-filed. Even if you're pro se, you have to have everything e-filed so that nothing touches the bench. Pretrial evidence, like I said, no discovery and heads blown, but you're talking about a period of, a filing and then a hearing in 2 weeks. You can ask for it. I wouldn't recommend it, especially if you're the landlord, because you're only going to slow things down.
And if you're not used to asking for discovery in JP court, if you do ask for it, it's always, well, not always, but most of the time it's going to be better to have those questions ready and attach them to your motion when you request with the court, because they're going to want to be able to decide if it's reasonable.
There are no counterclaims. Yes, it's a lawsuit, but if somebody comes in there saying, oh, but they violated all these things, there's no counterclaims. They get thrown out right away. So that's just wasted. And the court will take your money. But it's just wasted. Everything is just a defense. You can't bring anything else up about how awful the landlord was. It's just about why can't they evict you? Repair and remedy is one. That's something was broken. I told them to fix it. They didn't fix it. Now they're evicting me, and as retaliation.
Or I withheld my rent because something wasn't working in the house that I was renting. And there are notice requirements for that, and a lot of people take missteps there. On the alternative retaliation, I told them that it was broken, and therefore now they are evicting me. That one is a problem if any rent is owed, because that doesn't work that way.
Right, and then you could do an entire selling system, repair and remedies and retaliation to show you how complicated that is and why it's such a rare defense to win. The big one, the elephant in the room that throws everything off is title. Obviously, JP courts cannot hear title disputes. And so when the word title comes up, it's a giant red flag that sends everybody running to the hills. It is the one way to really slow down and completely put the freeze on an eviction lawsuit. The best thing to do is, if you're worried that there's a title issues being, oh, he sold me the house, oh, we agreed that it was rent to own, something like that, bring a deed. And that could head it off. If you think this could come up, just, get ready, because you're going to have to tell your client, we might go to the eviction court and we might end up in district court, and this might take a couple years and to figure out this title claim. I've seen it. It's absolutely no fun. So if you can avoid the title issue by bringing a deed, it's the best way to hedge it.
And the deed still might not stop a dispute. Okay, and for answers at the eviction level, an answer is not required. The defendant can just appear for trial on the date. They do not need to file an answer. Some do, some don't. One thing that filing an answer does help with is that if there is an appeal, that answer will carry over as an appearance for the county court appeal too. But there is no requirement. A lot of people expect if a tenant has not answered, then they're going to get their default. No, you can still see your tenant on the day of as a landlord. That's just how it works.
Most evictions get by with just these three things. Some will follow formal rules of go to the bench and evidence. Some will even be as simple as raise your hand and swear that this is what the deal is. Judgment sent, you're out the door in 30 seconds.
And I have on here a postal white card is what we like having. The reason I don't have a green card is because sometimes you don't even get the green card back. Very rare that you'll even get that kind of turnaround with how fast these trials happen.
Or a couple months later, you'll get it returned to you and you'll laugh. As far as every trial, they can slow things down a lot. Even in Montgomery County, which is relatively sparse in the east side, if you filed an eviction today and they requested a jury trial, you'd be in October.
we've had where we've been told they're ready for the jury trial. We've shown up, not enough jurors have shown up. And this is all pre-COVID-19. So it'll be even more interesting to see what happens moving forward with that.
Timelines, they have to move extraordinarily fast for lawyer purposes. There are times that they have to be held and all that. It's JP Court, you're just at their mercy. As for default, a CRA affidavit is one thing you really need to get one. And you still have to prove your case just like any other default. Post-judgment, this is post-judgment JP Court, they have 7 days to appeal. To appeal, they can either file a double the judgment, they can or they can just walk it. It's right there in the clerk's office, an affidavit of inability to pay the court costs. Now, you can challenge this affidavit of inability to pay. You file a notice with the court within just a day or two, and you can have a hearing on it. Two issues on that. One, it slows everything down. But two, if you have a really great argument for why they can deny the affidavit, either, they just filled out 0000, I make no money, I've never made any money in my life, and I own 0 possessions, even though you have evidence that you have a car, and they just lied. Simple things like that can have the affidavit thrown out, and ta-da, you're done. The appeal fails because they're not going to come up with the double bond.
It's easy for a landlord to get caught up in the excitement of a judgment in their favor. Make sure to have a discussion with any landlord clients, especially about the realities of collection of any damages on the eviction process. I know that we mentioned a lot that the goal is really to regain possession, and I think a lot of it is because people get caught up in the dollar signs, and so often they are left unsatisfied there. And it's not because nobody's doing the process or nothing was done wrong. It's just there's no method for collection.
The appeal process is pretty complicated. While you're in JP Court, as soon as the appeal's filed, the JP Court likes to kick it down the road. But there's a few things to do there, like the contest. Now, one thing is that if you're on a non-payment of rent case, when they file, they have to pay a month's rent into the JP Court registry. And so if they don't do that, the appeal can fail. If they do that and forget to pay it later, we'll get into the fun part. Now, the appeal bond, you can still appeal that when you get to county level, in that gray area between courts. And so you can sometimes win there too. When I say appeal, it's a funny word.
You may want to explain your typing ahead. I don't know. Can you guys still see my power? I got control over the PowerPoint. I still can't see anything else. But
Yeah, we can still see.
okay.
Cool. So the appeal itself is an appeal in name only. It's trial de novo. It's like a try again. There's no standard of review or anything like that. And so watch the days when you have an appeal. When a new month starts, call the county court register and say, did they pay their money? And the county court will say no or yes, or, oh, we got something. Oh, is that from the JP court? Because the tenant has a duty to pay rent as it comes due to the county court registry. And this is going to be where the attorney adds value, because it's very rare that the tenant knows that they need to do that. They get a letter from the clerk and everything, but they don't do it. Or they do try to pay the JP court, and the JP court turns them around. And so it's rare that they actually pay the rent into the county registry. And this is where you can file on the day that it's due, on the day that it was, the day after, really, it was supposed to be due, default for immediate possession because they failed to pay. This gets you away from a trial. You still have a trial, oddly enough, but you can get immediate possession, and that's the entire objective. After possession's granted, that's the game.
These are just some more of the code language. I wanted to make sure that some of those words were on there, but I won't read them or anything. As far as the actual appeal format, the appeal trial will look much like the JP trial. It may be more formal depending on the court. Actually, it will likely be more formal because a lot of the JP courts are very informal. Be prepared to start from the beginning. Prepare your client that they're going to have to explain it all over again. more than at the JP level, appeal judges will try to get people to go out into the hallway and to negotiate. We find it's very helpful, especially with a landlord client, but also with a tenant, to explain to them that this is likely to happen, because in the JP court, they're trying to get everything done very, very quickly. So you will not have done this. And a lot of times emotions are very high and people are not really willing to talk, but to just know that they're going to have to go give a fair attempt and talk to the landlord or the tenant.
Right. Just know that if you are downtown Houston on an eviction appeal, you will probably have to go in the hall for a while. Just be ready for it.
Okay, the appeal to the appeal. This is just to note that if you're going to see an appeal of that county court trial, it's going to be only for residential, and those are very, very rare because the bond on them is very, very high.
Yeah. But one of the great things about JP court is that they pull out of the work for you, like drafting the judgment. Whereas when you get to county court, it's your job to do the judgment, obviously. So on your judgments, make sure that you say judgment for this amount, award possession. You got to write that in, and that you need to have a bond. And the bond, I always leave it blank. Every judge likes to write in their own bond amount. It's going to be 10 times the rent amount. Leave a blank for them. Another thing that is helpful at the appeal level is that if everybody did the thing that they're supposed to do right in collecting the late rent, there's money there in the registry. And so just to save your client time and money and save you time and money, when you go to do the final trial at appeal, bring a motion to release bond and an order to release bond. You can, some courts have this online. Otherwise, you might have to go back and forth to get everybody happy with the language, but bring your motion in order to release the bond with you. You can get it signed right after the judgment. And it's a little better than usual because your client is going to get a check and it might be for what they were already owed, but it's still something nice and you can help move things along.
For the writ of possession, that's the ultimate goal as far as getting the property actually vacated. If the tenant doesn't voluntarily vacate, that's what you're going to be looking for. The writs are handled by the constable. If the tenant's not out of, so that the constable will show up, give 24 hours, say that you need to be out of the property. If the tenant is not out, then the next step is that the removal of the property will have to take place with the constable present. That does not mean that the constable is moving the property out of, or moving the personal property out of the real property. It means that your landlord or a property manager or whoever is going to have a group to move all of the furniture and belongings out onto the curbside, and that you're going to need to have someone there to change the locks. And a lot of times, you think, oh, well, 24 hours. Sometimes the lawyer doesn't even know that the constable is going out to serve this writ into the last second. So it's always good to have, if you're going to dabble in these or do evictions, do have a moving company and a locksmith that you trust, that you work with, if you're going to represent a landlord.
Yeah, have guys ready, have somebody who can lock. And a lot of the locksmith places around Houston, they know this and they know how to work on their schedule, because you file a writ of possession and it's like $100, it's like $150, file it, get the writ, and you might get a call the next day that says, I'm going to go serve the writ. Can you be ready on Tuesday? Oh, you might, I've had one that took a month and a half. One of the funny things about this is they can't serve it in the rain. So if it's really rainy, it might take a while. But as far as it goes, the constable is just there with a badge and a gun. Everything else about it has to be you. As far as the furniture goes, it's their call what qualifies as furniture. Does that bookshelf qualify as furniture? These couches? Yeah. What about that printer over there in the corner? Is that furniture? And so you just you're kind of at their mercy on this. My greatest fear is having a property that is landlord furnished that I have to get a writ of possession for, and trying to argue with the constable that, no, I don't need to take my client's couch out to the curb. So just be ready that could be an argument that you have to have with a constable. And maybe you have to haul your client's furniture out to the curb and haul it back in.
Okay, this just goes through some of the timelines and things with how they have to post the writ of possession. I won't go into that, post-possession damages, talking about the trying to collect anything for when you do get into the house and you see that there are problems with walls, furniture, all the fun things that you have when you have someone that is doing rental. Aggressive collection attempts post-possession are rarely effective. Like we mentioned before, lots of times you're dealing with a judgment-proof defendant. One of the things that you do look to, security deposit for damages. Most security deposit provisions and the code will allow you to use it for unpaid rent and for the damages, but this does not mean that the tenant cannot sue for recovery of that security deposit. You can still have it where you have, removed somebody and you've paid for the damages out of it and you've got, $10,000 left of damages. You can still be sued as long as they go in and they file the case, and you will have to defend it. And a lot of times that's a little jarring for people, but it is of course possible.
As far as collections go, what I just tell my clients is get your judgment from the eviction and go file an abstract of judgment and move on. One day you might get a phone call, but that's the most that I would recommend you doing as far as collection, unless there's circumstances that are unusual, a very high wealth client that owns a bunch of stocks and things like that, in which case have fun. But most people are just your regular people. They're tenants that it's not like they have vacation homes. They don't even have a homestead. So get your abstract, file it away for the $12 and move on to the next case. So the next and last is effectively commercial evictions. The state of Texas lets people who are doing commercial issues kind of handle their own problems, which is nice. So most of your issues are going to be what the lease says, which I know is not the best legal advice, but it's effectively going to be where all of your issues are going to come from. With commercial, you don't see so many commercial evictions because the commercial landlord has the remedy of a commercial lockout that the residential landlord doesn't have to the extent that the commercial landlord does. E.g., residential landlords can lock the tenant out, but they got to hand them a key. What's the point in that? Commercial landlords can say, I'm locking you out until you pay me my rent. And so a lot of the times a commercial lockout does what an eviction would, it's just it's right now. So that's why we don't talk about commercial too much, because it has a remedy that is so much more effective than the fun of a 1 to 4 month eviction lawsuit.
I think that is it. So if there are questions, I know we are out of time, but we're happy to address anything.
Not seeing any of our live with questions.
I see us. Okay.
The only question we have on the chat is if you wouldn't mind if we made these slides available for download through our website.
No, that's fine. I noticed a couple typos, so if nobody judges too harshly, then
I would say that the one among us who has never made a typo could be the first one to cast a stone regarding that. But anyway, thank you so much. I know it wasn't flawless, but I think we did pretty well as far as rolling with the few hiccups that we did have. We certainly thank everyone for coming and participating live. We thank those who are participating through Zoom. And we were not able to get it going to Facebook as well. That was just a little bit too much, but I think 2 platforms is plenty for our group, the live venue here and the Zoom platform. Wonderful presentation from both you, April and Robert. Very informative. We appreciate the time that you spent not only today, but just for everyone's awareness, we did do a tech rehearsal, a dry run through on a day to make sure everything was working properly. And we did get it working properly, but we still had to roll with a few wrinkles. So thank you everyone for your patience. I'll put her on the spot for a minute, but Ruth Ann is here live with us, and she is going to be our next president. And it's been a pleasure working with her this past year, and she's made pretty much everything happened from lining up all the speakers to making sure that everything else is on track. She's going to do a phenomenal job. She wants to take a minute and introduce herself for anyone who hasn't met her before. She can do that, or she can save it for next month when I'm sure we'll be back. Okay, she'll save it for, again, I didn't give her any advance warning, so I was putting her on the spot, but I just wanted to let you know that as we transition to the new board, that we're in excellent hands. The only other thing was the course number. For those of you who came here today, you registered through the website, and we will be getting your CLE credit for you. For anyone who's attending Zoom that didn't notice in the chat, I posted the course number, but I'll just give it to you here now. The course number is 174089974. Again, that course number is 174. You know what? Let me do this. Just in case I'm muffled. Course number is 174089974. Thank you all, and let's give a round of applause for our speakers and send them off.
Thanks for having us.